Look, it's going to the foundational question. Did Donald Trump disqualify himself by engaging in the insurrection? You would think with such a big case that the potential candidate would want to come and give their side of the story. He's not planning to testify. He's not giving deposition. And for someone who just loves to grandstand about the cases against him, his silence compared to what his testimony would be under oath is deafening. In terms of the posture of the case, I think there are people who would say there are a lot of big open questions about Section 3 of the 14th Amendment. So it is a positive thing to have a court weigh in, and ultimately, it's how Colorado's system works. Voters have the ability to challenge ballot certification, challenge the type of processes that will play out, and a court gets to weigh in with presidential primaries.
This is Michael Popak, Legal AF. You just heard the Secretary of State for the state of Colorado with a big head scratch. Why isn't Donald Trump showing up next week at his trial that could ban him from the Colorado ballot by way of the Secretary of State, that person you just heard from right there, because of his disability under the U.S. Constitution, 14th Amendment, Article 3, which particularly bans from office anyone who has engaged in insurrection or rebellion, which is an automatic disqualifier, without any other mechanism. It's self-effectuating, self-executing. It's really important. I got two questions for Donald Trump. One, why aren't you showing up at your own trial, and why are you not presenting any evidence, apparently, to the trial judge who's going to be presiding over this case, Judge Wallace, Sarah Wallace, who has a number of questions that she wants answered during the trial, but you don't seem to be prepared or willing to answer any of them. And then, therefore, you will be tried in absentia, if you will, like any dictator. And if the judge decides based on the evidence presented by the plaintiffs in the case, as supported by the organization that's supporting them, the Citizens for Responsibility and Ethics in Washington, CREW, you will not be eligible to be voted upon by the citizens of Colorado come the primary or the presidential election. That's my first question. Here's my second question. Why did you hire the lawyer that you're currently using to handle this matter when you knew or should have known that Scott Gessler, who had been the Secretary of State back in 2012, actually took the position contrary to the one that you're taking now in court, allowing the lawyers for the plaintiff to cite Gessler's own case against him time and time again in the pleadings and in the motions? Let me break that down for you. Scott Gessler has a 3-person law firm in Colorado, and he is, by himself, the lawyer for Donald Trump in this case. Now, if you look at his biography at first blush, it seems pretty good. He was the Colorado Secretary of State back in the 2012s or so. He had been in the Department of Justice and as a U.S. attorney, assistant U.S. attorney. He had even served our country in the U.S. Army in the JAG Corps as a lawyer, and he's an election law expert. I get that. Usually ex-Secretary of States are election law experts, but if you just scratch just below the surface, Trump, you would have realized that Gessler had a case that was very well known and publicized, made it all the way up to the 10th Circuit Court of Appeals, where then Judge, now Justice Neil Gorsuch, actually wrote the decision in favor of the proposition that a Secretary of State, in this case you, the lawyer for Donald Trump at the time, had the power and authority to ban somebody from the ballot who was running for U.S. president. Sound familiar? Because that's exactly what is going on here. Note to Trump, you may not want to hire the lawyer who has the preeminent case on the books in Colorado that's exactly 100% contrary to your position representing you in the trial. So in a little bit of a more facts on that, in 2012, there was a naturalized U.S. citizen from Guyana. His name was Hassan, or Abdul Hassan, and he wanted to run for president. And, if you're naturalized, it causes some problems because you have to be a natural-born citizen in order to be a president of the United States. But Hassan argued that the Secretary of State of Colorado, much like what Trump's arguing here, doesn't have the power to do that, that only can be decided by Congress at some future date if he ever, won the election. And unfortunately for Trump, his own lawyer, then Secretary of State, took the position as follows. He defended his own authority. This is Trump's lawyer back in 2012 when he was the Secretary of State. Quote, the Secretary further affirmatively states that in accordance with Colorado law, any candidate who does not meet the minimum constitutional requirements for the office of the presidency may not be placed on the ballot for that office in his filing. And the 10th Circuit, in a decision written by now Supreme Court Justice Neil Gorsuch, wrote that it was exactly right that a state has the right to deny ineligible candidates a place on the ballot. And particularly, Gorsuch went on to write in a quote that talk about hoisting somebody on their own petard they are using against Donald Trump and his lawyer right now. The quote from Gorsuch is, quote, a state's legitimate interest in protecting the integrity and practical functioning of the political process permits it to exclude from the ballot candidates who are constitutionally prohibited from assuming office. Judge Gorsuch responding to a position that was properly taken by Scott Gessler, now the lawyer for Donald Trump. You got a problem when your own lawyer's precedent is being cited against you, because it's exactly what the 6 plaintiffs are trying to do in Colorado now. They're trying to use an ineligible provision or a disqualifying provision of the 14th Amendment to have the Secretary of State ban Donald Trump from the ballot. And under that 10th Circuit case law, which is binding precedent in that district and on this judge, ultimately, the Colorado Secretary of State has the power. Now, the judge going into this trial has already handled a number of motions filed by Donald Trump and this Scott Gessler over and over again to try to get the case dismissed. And she's denied it every time, picking apart one by one each of their arguments as to why fundamentally now Gessler reversing course 180 degrees and saying, sure, when I was Secretary of State, I had the power, but the current Secretary of State's a Democrat, so she doesn't have the power. I mean, that's not exactly what he's saying, but that's sort of what he's saying. And the judge has already ruled, based on motions filed by Mr. Gessler for Donald Trump, that the Colorado Secretary of State, of course, does have the power to ban people from the ballot, and that the provision of the 14th Amendment, Article 3, about who engaged and who's an insurrectionist, it can be decided by the courts, but then ultimately it's self-effectuating, it's self-activating, meaning it doesn't have to go back to the Congress. In fact, there is no role of Congress, according to the judge and to a plain and fair reading of the 14th Amendment. There is no role of Congress to decide the eligibility of a president on the ballot. Maybe when the electoral certificates under the 12th Amendment and other amendments, maybe under that, when the certificates finally come in, they can decide yes or no, yep, up or down, valid or not valid. But at the primary and on the ballot for the presidency level, that's a Secretary of State issue, state by state. And this 10th Circuit case in which Trump's own lawyer made the precedent against him is the binding precedent. So going into the trial, having already resolved a number of these issues and denied motions for dismissal and motions for summary judgment, here's what's left for the decisions or the issues for the trial coming up starting on Monday. This is all according to the judge. It's not my words. It's the judge's words. The judge wants to get to the bottom during this trial, bench trial again, no jury. Evidence being presented by the plaintiff, looks like little or none being presented by Donald Trump. Question number 1. What is the definition of, quote, engaged and, quote, insurrection as used in the 14th Amendment, Article 3? You'd think those things would be defined, but they're really defined through a series of cases in case law that will be argued in front of this judge and legislative history about this country after the Civil War and the Reconstruction period, and why the legislators originally put on the books something to ultimately ban Civil War Confederate leaders from resuming their post or running for office in the new Union, the new Reconstructed Union, unless Congress took away their disability through a 2/3 vote of the House and a 2/3 vote of the Senate. A point, by the way, that the Judge Wallace, has reminded Donald Trump, almost teasing him because she knows he doesn't have the votes in Congress to take away his disability. She says in one of her footnotes in the recent order, before this trial even starts, during the trial, after the trial, you could have Congress with a 2/3 vote take away your disability, declare you fit for office, and you could go back on the ballot. The Senate too, but he doesn't have the numbers for that, and he won't. To get 2/3 of the Senate, he need like 260 votes. They don't have 260 votes of the Republic. They barely have a majority in the House. In the Senate, they need 67 votes. They're never getting 67 votes. They've only got about 50. I think they've got 49. So they're never going to get that many Democrats to allow Donald Trump to run. But I like that judge because she sort of teased him. You want to take this away from me? Go to Congress. Oh, you can't do that? Then we're going to trial on Monday. It was sort of like that. The judge said, here's the other things I want to determine by the time the trial is over. This evidentiary trial is over. I want to know not only what are the definitions of engaged and an insurrection, I want to know whether Trump engaged in the insurrection. It's very interesting that the framers of that provision of the 14th Amendment, Article 3, chose the words engaged. They didn't say convicted. They knew that these people wouldn't have been tried and convicted in a court of law. They said engaged, and then left it open as to who should evaluate whether they did or didn't engage. Of course, the normal place you evaluate people's culpability and liability is in courts, and that's why we're in court, and then with direction or an injunction to the Secretary of State about what to do off of the court's ruling. So did Trump engage in insurrection? Looks like the weight of the evidence is going to be tremendously on the plaintiff's side, with Donald Trump just making legal argument, not even bothering to show up and testify. Some of the questions she had originally asked, she already answered for herself off some recent filings. For instance, does Congress need to take any action about somebody's disability under the 14th Amendment, Article 3, or is it self-executing? She's already answered it based on the analysis, and she's right, historical analysis, that it is self-executing. You don't go back to Congress to ask them to make a determination about whether a presidential candidate engaged in insurrection or not, whether they are a former president or just a candidate anew, fresh right now. So she's already made that ruling. Does the 14th Amendment, Article 3, apply to presidents of the United States? And she's already answered that as yes, having interpreted the fact that they also uphold the Constitution, because it's the Article 14, 14th Amendment, Article 3 only applies to federal officers who at one time swore to uphold the Constitution and then engaged in insurrection or rebellion. And they had some cockamamie argument on the Trump side that he never swore to uphold the Constitution. His oath of office as the president is slightly different about his role with the Constitution. And the judge says, no, all those words there just mean uphold the Constitution. And of course, it applies. And that's it. I mean, that's what the case is going to be about starting this week. It's just fascinating to me as we open this clip that the couple of things. Donald Trump's not showing up. This could really lead to him being banned from Colorado. Sure, it'll be taken up to the Colorado Supreme Court, maybe flip over to the feds, maybe over to Neil Gorsuch again, who's sitting at the U.S. Supreme Court and sits as the duty judge in this particular area for all appeals from that area. But there's a very real threat that he's going to be banned from the ballot. And if that happens, watch other states try to do the exact same thing. They're all, secretaries of state are all sitting and watching the Secretary of State for Colorado carefully here. And then, of course, the results. We'll follow it on the Midas Touch Network. As we get information each day about the trial, we will update you in hot takes just like this one, because we sit at the corner of law, politics, and justice so that you don't have to, and bring it to you here. Only one place, the Midas Touch YouTube channel, on hot takes just like this one, and then on Wednesdays and Saturdays on the YouTube version of Legal AF. It is what you think. It's the leading podcast of its kind. I co-founded it. I co-anchor it along with my co-anchors Karen Friedman-Agnifilo and Ben Meisalis